Assalamualaikum and a very good morning again to Dr. Susanna and my classmates. So today Group 2 will be presenting about the last three topic that we will be learning for this course. So I pass to Lukman.
The first part that I will be talking about is about the membership and the members' right. Okay. The significance of being a member. The first one is a member is entitled to vote at general meetings. And secondly, a member is entitled to receive dividends if a company is in the process of winding up. Members may liable to contribute towards the payment of its debts. Members also entitled to share in the company's surplus asset on a winding up. Members also can do petition for a remedy. This is under section 181. For the case example, we use Owen Sim Liang Kuang versus Pisau Jaya Sendirian Berhad and Arno. The appellant applied to court for a remedy under section 181 subsection 2, which is the remedy in cases of an operation. But it was argued by the respondent saying that his name is no longer in the register at the time he commenced the action. Then it was held by Gopal Sriram that a petitioner who applies Section 181 must be able to demonstrate that his name appears on the company's register at the date of petition. If he fails, he has no standing to invoke the jurisdiction. Next. So, the second part is about the infringement of members' right. We will look into the rules in Force versus Habotel. The first one, right of a member to bring action to remedy of an internal irregularity or a wrong committed against the company is stemmed from the rule in Force versus Habotel and its exception. The rule was based, it is generally appropriate for disputes to be resolved in accordance with the Constitution and the vote of majority. Courts were reluctant to interfere with these processes. Exception was made in order to give standing to members to bring legal actions in order to enforce personal rights as a member. Members were also given permission to bring legal actions to enforce a right of the company in circumstances where the company failed to do so. Okay, the first rule in the Force versus Habotel is the internal management rule. Based on the court's reluctance to interfere with internal irregularities which are capable of being rectified by ordinary resolution of a general manager of members. The second rule is the proper plaintiff rule. It is a recognition of the separate legal entity of the company. When a wrong is done to a company, then the company itself is the proper plaintiff in any legal proceedings which seek to remedy it. The third rule is the effect of the rule. This is the rule of majority rule. There are two parts in the majority rule. The first one is if a wrong is alleged against the company, then the proper plaintiff to sue in respect of the alleged wrong is the company itself. The second part is if if a company officer have committed irregularity that can be ratified in general meeting, then no individual members can sue in respect of the irregularity. Next. Uh, for the common law exceptions to the rule in Force versus Habotel, there are 6 exceptions. The first the act of the company is ultra vires. Ultra vires means that it is above the power of the above their power. The second one is where the act of the company requires a special majority. The third one, where a member's personal rights are infringed. The fourth, where the majority of members commit a fraud on the minority. The fifth, bona fide for the benefit of the company as a whole. And the sixth, which is the last, where the justice of the case is required. Next. So the next part is about minority protections of shareholder. According to Company Act 2016, there are 7 of the minority protection that I will talk about. The first one is the rights to appoint a director. So minority can negotiate for a right to be appointed as a director, or to nominate a director, or appoint an observer, which is they who cannot vote at a board meeting. The second is the information rights. So the minority shareholders can negotiate for a specific right to access information and documents which is related to the company with a reasonable notice and frequency. The third one is that reserve matters. Okay, in this part, the shareholders agreements can provide laundry list of reserve matters that the directors cannot do without obtaining the affirmative vote of the minority shareholders. This also includes corporate actions such as expenditure above specified amounts, expanding the business into new markets, or other significant decisions such as hiring key management positions. Next. The fourth one is preemptive rights and rights of first refusal. What it means is that preemptive rights ensure that any newly issued shares shall first be offered to existing shareholders. This include minority shareholders on a pro-rated basis and not just to a selected few. Similarly, right of first refusal ensures that any shares which is sold by an existing shareholders shall first be offered to other shareholders on a pro-rated basis. So both the above rights are anti-dilution mechanism which allow the minority shareholders to retain their percentage of equity in the company, or even to increase their equity ownership if they desire. The fifth one is tag along. Tag along rights compels the majority shareholders who are selling their shares. This is done to allow the minority shareholders to participate in or piggyback into the sale of shares on the same terms and conditions as the majority shareholders. Typically, the rights can be exercised at the election of minority shareholders, which is where the situations the minority shareholders do not wish to remain in the company with an unknown new shareholder. Next. The sixth one is the put option. Uh, The put option gives minority shareholders the right to sell their shares to another shareholder in certain situations, such as in deadlocks or upon the company's failure to achieve certain agreed milestones. In essence, it will compel another shareholder to buy out the minority shareholder. This is particularly important for private companies, which is limited by shares, given the lack of liquidity for minority shareholders to dispose their shares to the third parties or in the open market. The seventh one, which is the last one, is valuation. When the minority shareholders has decided to exit the company, then the minority shareholder will need to dispose their shares. So it is useful for a valuation method to be specified in the shareholders agreement when the sale of shares by minority shareholders to properly reflect the contributions of the minority shareholders itself and the value of the company at the point of sale. If they fail to do so, a minority shareholder may even face an unexpected discount to its share value due to the lack of third-party buyers who are interested in acquiring in a minority interest. Next. Okay, next I will be passing to Firdaus for the presentation of company meetings.
Thank you, Lukman. Assalamualaikum warahmatullahi wabarakatuh. My name is Firdaus, and today I will present on company meetings. So a little bit of a context. Earlier this month, I was reading the news, right? And apparently, there is a public listed company who has gained the spotlight because of an issue with its auditor. Apparently, the company announced that the auditor has found that there's some issues uh, that has been found upon auditing, and the company said that no, there's nothing wrong. You know, with the transactions, everything is fair, true and fair. So the company asked the auditor to quit, and this is not like any auditor; it's one of the big four. You know, so the company management asked the auditor to resign, but the auditor refused to do so. And so then the company management actually asked or gave out a notice to remove the auditors. So after reading this news, it got me to question how does a company remove its auditors, right? So next slide. So from the Companies Act 2016, Section 276, subsection 1, the members of a company may remove an auditor from office at any time by two ways. One, by ordinary resolution at a general meeting, and two, in accordance with Section 227, which is that a special notice shall be required for a resolution to remove an auditor from office at a general meeting of a company. Right, so next slide. So what is a general meeting first, right? Let's look at the general meeting. So one of the meetings is called annual grand meeting, which is AGM. And Section 340, subsection 1 states that every public company shall hold an AGM in every calendar year, in addition to any other meetings held during that period to transact. And this is to laying the audited financial statements and the report of the auditors, directors, and auditors, to re-elect of the directors in place of those who have retired, the appointment and the fixing of the fee of directors, and any resolution or other business of which notice is given in accordance to Companies Act 2016 or the Constitution. Next slide, please. And then subsections 2 states that for the purpose of section 340 subsection 1, the AGM shall be held within 6 months of the company's financial year end, and not more than 15 months after the last preceding AGM. So this is AGM, right? So it got me thinking, okay, this might be a little bit different. So what is the other meeting? Well, the other meeting is called the extraordinary general meeting. It's like a meeting that could be called by the companies such that they issue a notice, right? And from the statements that has been stated before, we know that an auditor could be removed by two possible ways. That is such that in the way of ordinary resolution, or the other way is the special resolution. So Section 291 subsection 1 states that an ordinary resolution of the members or a class of members of a company means that a resolution passed by a simple majority of more than half of such members, whilst a special resolution is when members or class of members of a company uh, gave a notice of not less than 21 days and passed by a majority of not less than 75% of such members. Next slide. Right. So based on that, we know I came to the conclusion that Serbo Dynamic could remove its auditors in two ways. Either is through a general ordinary resolution, in which that it could come up, which could bring up the resolution during a AGM, and only needs 50% to pass the resolution, or we could come up in a special notice resolution. But when that happens, the company needs at least 75% in order to remove its auditors. Right. So in this case, since the company is not going to organize its AGM, then it's probably going to be the special notice resolution, right? So upon walking down that path, I then ask or wonder, how can a company organize a general meeting right now, since it's it's days like this, days like today, we are currently under the full MCO, in which that no gathering, no matter how small, is allowed, right? So how do companies are actually gonna organize these meetings, right? So apparently, um, the Companies Act actually stated ways for a company to organize a meeting, regardless of MCO or not. And Section 327, subsection 1 states that, subject to the Constitution, a company may convene a meeting of members at more than one venue using any technology or method that enables the members of the company to participate and to exercise the members' rights to speak and to vote at the meeting. And the main venue of the meeting shall be in Malaysia, and the chairperson who will be conducting the meeting shall be present at the main venue of the meeting. Then I came to the conclusion, oh, that means that this public company, as is going to, propose the resolution to remove its auditors, can actually conduct a general meeting by using technology or methods that we as students use as well, like Microsoft Teams or Google Meets or stuff like that, just to pass the resolution. So I guess that is all for me, just to share a little bit of my reflection when it comes to like reading about news in the everyday lives and relating back to the information and knowledge that I've learned in law class. Thank you very much. Assalamualaikum.
So, Assalamualaikum. My name is Hakim, and I'll be presenting about the winding up of company. So next, winding up by court. First one is the winding up by court. Winding up by court, also known as compulsory winding up, where it begins with the presentation of a petition in court. So petition can be made by the company or any creditor, a contributory, liquidator, the minister, the Central Bank of Malaysia, and also the registrar. Next slide. So there are circumstances to be wound up by court. First one is the company, when the company is unable to pay its debts. This is stated under section 466 of Company Act 2016. The second one is where the company does not commence any business or suspends its business for a whole year. The third one is when the company has no member. The fourth one is where the company has by special resolution resolved that the company is to be wound up by the court. Next is when the director acts in the director's own interest rather than in the interest of the company and other members. The next one is when the company is being used for unlawful purpose. And the last one is where the court opinion that it is just and equitable that the company to be wound up. So next slide is the example cases for the winding up of a company by court. The first one is Tan Kien Kiong against Tan Eng Hong Paper and Stationery Sdn Berhad and ORS and other appeals. In this case, the petitioner alleged that the directors had acted in their own interest rather than in the interest of the members as a whole by siphoning funds into separate family funds, hence making it just and equitable to wind up the companies. The second case is Ng King Chong and Eno Nation Park Sdn Berhad and 2 ORS. In this case, the allegations are made that the director have acted in their own interest and that there is a loss of confidence amongst the members of the company, severely affecting the operations and management of the company. So the same is similar to an operation petition. Next slide. We're going to see the commencement of winding up by court. So the winding up of a company shall be deemed to have commenced at the date of the winding up order. Power of court on hearing petition for winding up. Upon hearing the petition, the court may, first one is to dismiss the petition with or without cause. The second one is to adjourn the hearing conditionally or unconditionally. The third one is to make any interim or any other order that the court thinks fit. So if a winding up order is made, the court shall appoint an official receiver either under section 477 or Section 478 to settle the winding up process for the company. So next slide, where we are going to see the voluntary winding up. So basically, voluntary winding up is a formal winding up process initiated by the directors and shareholders of the company, and this process does not involve the court. So for the circumstances to be wound up voluntarily, the first one is where the period fixed for the duration of the company by the constitution has expired, or in the event which the company ceased to serve its intended purpose to exist. Second one is where the dispute amongst directors and shareholders that leads to a resolution in general meeting requiring the company to be wound up voluntarily. And the last one is when there is a resolve by special resolution. So when the company want to wind up voluntarily, what the director and the members shall do. So what company should do after the resolution? So the first one is the company have to lodge a printed copy of resolution with the registrar. And the second one is the company have to give notice of resolution in one widely circulated newspaper in Malaysia. This can be made either in Malay or in English language. Other than that, the directors also shall immediately appoint an approved liquidator to be the interim liquidator after the declaration has been lodged. So what is the effect of voluntary winding up? The first one is the company have to stop the business from the commencement of winding up, except so far as is required in the opinion of the liquidator for the beneficial winding up. The second one is, despite anything that in contrast with the constitution, the corporate state and corporate powers of the company shall continue until it is dissolved. For the third one, all of the transfers of shares, alteration in the status of members after the winding up is void. So next slide. Next slide is the members voluntary winding up. Members voluntary winding up is an efficient way to wind up a solvent company, as the company realizes that all of the assets are sufficient to repay all its liabilities. So in this voluntary winding up, directors have to execute and lodge the declaration of solvency (DOS) with the Companies Commission of Malaysia (CCM). So what is the DOS? Declaration of solvency is a written declaration from the directors stated that an inquiry into the affairs of the company has been made, and at a meeting of the directors formed the opinion that the company will be able to pay its debts in full within a period not exceeding 12 months after the commencement of the winding up. So a meeting of shareholders will be held to pass the resolution to wind up the company and to appoint a liquidator to facilitate the liquidation administration. Members voluntary winding up will commence at the date of the resolution. So after the settlement of the administration, the liquidator then will lodge the CCM or the Companies Commission of Malaysia the necessary documents, and 3 months after the lodgement, the company will be dissolved. So next slide. Next slide is the creditors voluntary winding up. Creditors voluntary winding up may be considered by the directors and the shareholders in the event that the company is insolvent but wishes to avoid a compulsory winding up initiated by the creditors. This process is quite similar with the members voluntary winding up, where the directors and shareholders initiate the process and nominate the liquidator. However, at the creditors meeting, they have the right to either agree or not towards the nominated liquidator by the company, or they want to nominate their own candidate to act as a liquidator. And this is stated in section 450 of Company Act 2016. So the liquidator then will carry out the duties which include the realization of assets and the distributions to the creditors. So the advantage of creditors voluntary winding up as compared to the compulsory winding up by the court is that the company may nominate their own liquidator, and this will make the entire process of bringing the company to an end is more efficient and cost effective when we compare to the company that have to wind up by the court order. So that's all from me.
So once again, Assalamualaikum. So today I am Muhammad Maharis, will be presenting about the arrangements and the construction of company. Companies with viable businesses may sometimes find themselves in financial trouble when they are burdened with large debt. In such a situation, they may be insolvent at that particular point of time. So, however, their businesses may still be viable if the debts could be restructured and an arrangement entered into with all their creditors. So under Division 7, Subdivision 2 on Arrangement and Reconstruction in the New Companies Act 2016, there are provisions by which the Malaysian court may assist companies to restructure their financial affairs. So, how can the Malaysian court help companies with such financial trouble? According to Section 366 of the New Companies Act 2016, the court's main power is to grant its approval and order a compromise or arrangement between a company and its creditors. This remedy is available provided a compromise or arrangement has been agreed by a majority of 75% of the total value of creditors or class of creditors present and voting in a meeting of creditors. Additionally, the court can order a meeting between creditors and shareholders to consider a proposed compromise or arrangement. The court can also alter and impose conditions if it thinks fit on a compromise or arrangement approved by creditors. Next. So, firstly, a court order on an application may be the company. Any creditor or member of the company, liquidator or judicial manager, if the company is under judicial management, to summons for a meeting is to be obtained. This is under Section 366 of Companies Act 2016. A notice summoning such a meeting is to be sent to every creditor or member of the company, accompanied by explanatory statement of the effect of the arrangement and any material interest of the directors and the effect of the arrangement if it has different effect on different class of creditors or members. And another one is the advertisement of the notice. This is under Section 369, subsection 1 of Companies Act. Next is the putting forth of the scheme at the meeting of creditors and members of the company to be agreed upon by a majority of 75% of total value of creditor presenting and voting, either in person or by proxy or at the adjudicating. This is under Section 366, subsection 3. And lastly, upon obtaining the requisite approval, a further order by the court is to be obtained to sanction the scheme of arrangement. So this is actually the arrangement schedule that the companies have to do. And next, I will be talking about the power of court. The court has the power to appoint an approved liquidator to assess the viability of the scheme proposed for the compromise or arrangement, and the liquidator is to prepare a report, of which is to be tabled in the creditors or members meeting. This is a mechanism by the court to ascertain the genuineness of such schemes and therefore not an abuse of the court's process, and to facilitate agreement by creditors and all members to the scheme of arrangement. If the court can be satisfied with the schemes, this will surely facilitate approval by creditors to the scheme, thus expediting reconstruction of a company. So, what is the advantage of arrangements by court? There are two advantages that I can search. The first one is the court powers to order compromise or arrangement with creditors and members, even though some creditors may not agree with the scheme of arrangement. So long as the state threshold over 75% is met, subject to the court's approval, the remaining creditors are forced to accept and compromise or arrangement. So the second advantage is the the insolvent company's compromise via the court is to take advantage of Section 368 of the new Companies Act 2016, which allows the court to restrain proceedings or actions against a company while it seeks a compromise with its creditors. This is akin to what is commonly known as bankruptcy protection for companies in the United States of America. There are, however, conditions to be fulfilled before a court can restrain the proceedings against the company. So the next subtopic that I will be presenting about is merger and acquisition. So firstly, we have to know the different firstly we have to know the differences between merger and acquisition. By definition, a merger occurs when two entities join together to create a new entity. For an example, the oil and gas sector merger between Kencana Petroleum Berhad and Sapura Kras Petroleum Berhad 2012, the result of which is now known as Sapura Kencana Petroleum Berhad. And acquisition, on the other hand, it refers to the purchase of one entity by another entity involving a share purchase exercise for ownership of a company without the creation of any new entity. So the example is the acquisition of MBF Cards Sudan Berhad by AMMB Holdings Berhad. Yep. So next, the types of merger and acquisition. In Malaysia, the most type of merger and acquisition is by way of share purchase. The legal framework, transaction structure, and process will depend on whether the entity being acquired is a public listed company or private limited company. So there are several other types of transactions that fall under the umbrella of mergers and acquisition. These are consolidation of businesses, formation of joint venture, acquisition business and or asset, acquisition of shares of company, and takeover scheme of arrangement under Section 366 of Companies Act 2016. So that's all from me. Thank you.
Okay, for receivers and managers, first we'll be moving to the distinction between receiver and manager. Expressed in the 1880 English case of Rare Manchester and Medford Railway, 1880, wherein JSLMR clarified that receiver means a person who merely takes income and pays necessary outgoings, while receiver and manager has all the powers of a receiver and additionally has the authority to carry on the trade or business of the company. For qualification and disqualifications in appointing receiver or manager, in section 372, it is stated that the qualifications of the receiver or manager is referred to section 403, which describes the qualifications of liquidator. The basic qualifications are an approved liquidator, not indebted to a related company in an amount of exceeding 35,000 ringgit, not a partner, employee of the company, or the partner or employee of any officer of the company. The person shall not be bankrupt and not convicted of an offence involving fraud or dishonesty punishable on conviction by imprisonment of 3 months or more. In section 373, the following person shall not be qualified, which are corporation and are discharged to bankrupt, mortgagee of any of the company's property, an auditor of the company, and an officer of the company or any corporation which is mortgagee of the company's property. Appointment. Receiver and manager is appointed either under an instrument or by the court. Under an instrument, the instrument must either confer on the instrument holder the power to appoint receiver and manager, or an instrument that creates a charge in respect of property and undertaking of a company that also confers on the charge holder the power to appoint receiver and manager. By the court, the appointment of receiver and manager is only on the application of an interested party, such as shareholder or creditor or a debenture holder. Appointment by the court is typically exercised to preserve and safeguard the company's assets from being dissipated. Next is the powers of receiver or receiver and manager. Receiver or receiver and manager shall have all the powers and authorities expressly or impliedly conferred by the instrument or by the court by the order of the court to which they were appointed. All the powers are specified in the 6th Schedule of the Companies Act 2016, although any of the powers can be specifically excluded by the instrument or by the court order appointing the receiver and manager. In general, a receiver or receiver and manager will have the power to take possession and control of the company's property, to lease it on hire, or dispose of the company's property, or sell the company's property. Receiver or receiver and manager also have power to carry on the company's business, to bring or defend any proceedings in the company's name and on behalf of the company, to inspect the company's books, and to execute any document on behalf of the company. Duties for receiver and manager. Upon being appointed, a receiver or receiver and manager must send a notice informing their appointment to the company. The company then must submit a statement of affairs which states details such as the particulars of the company's assets, debts, liabilities, creditors' names, and any such information required by the SSM within the next 14 days. Upon receiving the statement of affairs, receiver or receiver and manager has 30 days to do the following: lodge a copy of the statement of affairs with the SSM together with any comments which fits to make on the statement. Send a copy of the comments on the statement of affairs to the company, and if the receiver or receiver and manager is appointed by or on behalf of the debentures holder, send a copy of the statement of affairs and the comments to the debentures holder's representative. They must also ensure that the accounts of receipts and payments is prepared every 6 months from the date of appointment, and also that the same is lodged with SSM within 30 days from the expiry of each 6-month period. If receiver or receiver and manager is appointed, opposition is taken on behalf of any debenture holders secured by a floating charge. Then they must ensure that all liabilities that act in priority to the debenture holders are met. The potential liabilities are laid in Section 381 and Section 382, wherein Section 381 is stated that receiver or receiver and manager shall be liable for debts incurred by the possession of any assets of a company to enforce a charge in the course of the receivership or possession for service rendered, goods purchased, or property. In Section 382, subsection 1, they are personally liable for any contract entered into by them in the exercise of their powers. In subsection 2, receiver or receiver and manager can include clauses in any contracts they enter into of their capacity as the receiver or receiver and manager to exclude or limit their personal liability. That is all from our group. Thank you.